President Jacob Zuma and his legal team are given 1 month to prepare arguments in an open court before the Supreme Court of Appeal makes a ruling on the spy tapes case. Today's decision by the Supreme Court of Appeal is a break from the normal process and effectively throws the applicant, President Zuma, a lifeline to appeal an earlier North Gauteng High Court ruling that reinstated fraud and corruption charges against Zuma dating back to 2009. However, it's still a long way before the Supreme Court of Appeal will make a ruling.
And that will be the
usually the SCA does not hear oral arguments in an appeal case. Usually they'll make a decision based on the papers filed by the various parties, but they've elected instead to hear an open court arguments from either side. And as a Democratic Alliance, we're confident that the SCA will come to a similar conclusion as the Constitutional Court, which refused to essentially hear an appeal. We've long held that there was no basis for the charges against President Jacob Zuma to be dropped. It was an irrational decision, and this was confirmed by the High Court. And we feel that in an open court, this matter can be finally ventilated before the people of South Africa. And we have the view that this appeal will be rejected, and that the next step in that regard would be for the NPA to reinstate charges against President Jacob Zuma, the 783 charges of corruption, racketeering and money laundering.
In terms of the Supreme Court's Act, President Zuma's application has been referred for oral argument on a date yet to be announced. And when that happens, arguments will be made by the legal teams of both President Zuma and the respondents named in the case in an open court. But before that, there is some admin for the President's legal team. They will have to file 5 affidavits of the application for leave to appeal before the 11th of November this year, or 1 month from the date of the court order. And joining us in studio, Martin Hood, a criminal lawyer from MJ Hood and Associates. Martin, good to have you as always. This is unprecedented, though. Very interesting developments. What do you, or how do you explain it?
Hi, Cindy. It's not unprecedented, but it is slightly unusual in the sense that, bearing in mind the long history of this matter, it dates back to 2001, and there's been several court applications and appeals that have had to have been disposed of before we've gotten to this point. What happened was 3 judges in the North Gauteng High Court made a decision. They said reinstate the cases. They refused leave to appeal. Then the President and the National Prosecuting Authority took 2 different directions. The NPA went directly to the Constitutional Court. That has been refused at this stage. The President chose to appeal to the Supreme Court of Appeal, but he did not appeal as people would normally understand the meaning of the word. He had to ask the Supreme Court of Appeal whether he can get their permission to appeal. That is what we call a petition. Normally what happens is the Supreme Court of Appeal just comes back and says yes or no. In this case, they've said, we want you, Mr. President, through your legal team, to come and argue whether you should get leave to appeal. That is slightly unusual in the sense that it's not normally argued in the court. It's normally done on paper and the judges decide amongst themselves, and then you go and argue the merits of the appeal. So what the difference is here is they've said, come and argue whether you should get permission to appeal, and if we decide to give you permission to appeal, then you must be prepared to argue the appeal as well.
On the same given date?
It appears that's what they intend to do, yes, because they've indicated in their directive, be prepared to argue the appeal. So presumably, they've said in essence, be prepared if we decide to let you argue the appeal. Be prepared to argue it there and then.
What are the complexities of this case, notwithstanding that we're talking about the head of state?
I don't think it's that complex, to be quite frank, because if one looks at the judgment of the North Gauteng High Court, they decided that the decision of the National Prosecuting Authority to withdraw the charges was irrational. And it really comes down to two grounds why it was irrational. The first is that the then powers that be in the National Prosecuting Authority said, on the one hand, a court must decide. On the other hand, they then decided to withdraw the charges against the advice of the prosecuting team itself. And the basis for that decision was that the investigation was compromised by the so-called spy tapes. But the judges rejected that because they said the spy tapes are procedural. They don't deal with the substantive merits of the matter, and the substantive merits of the matter have yet to be determined, therefore reinstate the charges.
But I mean, since, as memory serves, the spy tapes have since gone missing, or there's no evidence that they actually exist, or whether there are even transcripts from that. So when the President and his legal representatives go and argue this petition for leave to appeal, what is it that they're going to base it on if there is a chunk of substantial evidence missing?
Well, that's a very interesting question, because the grounds of their appeal are technical in nature. So they don't deal again with the merits of whether the President should be charged or not. They are arguing, for example, that the decision to withdraw the prosecution was rational, not irrational. They're also arguing that it is not a decision that is reviewable. In other words, that the decision of the head of the National Prosecuting Authority is final, and it is not subject to any judicial scrutiny whatsoever. I think that's a very poor argument, because it clearly could lead to an abuse of power, which I think is a situation we have here, where the National Prosecuting Authority has been compromised.
Yeah, but exactly, is that the distrust or leadership vacuum, as you allude to, that has led to essentially the judiciary having to intervene in matters of state agencies?
I think that it is a deterioration in the independence of the National Prosecuting Authority. We have a long history of bad appointments, political appointments. We've had a recent decision where two senior deputy national directors have been struck off the role of advocates because of their conduct, and they have been criticized not by one judge and not by one court, but by many different judges in several different courts. So we've had over time a weakening of the ability of the National Prosecuting Authority, firstly to act independently, and secondly to act properly in accordance with its legal mandate.
Yeah, but I mean, vehemently, and Sean Abrams, head of NPA, has reiterated the fact that his unit or his department acts independently, and that this is the time that he will restore respect and pride in the NPA.
I think he's done exactly the opposite. I think he's made the National Prosecuting Authority the laughing stock of the legal profession by his recent actions.
And by that you refer to Pravin Gordon's charges?
By charging Pravin Gordon. It's a fraud matter of 1.2 million rand. It doesn't deserve his personal attention. And the latest media reports are that the financial services industry has reported many, many cases of multi-billion rand fraud, none of which has been personally or even prosecuted by the National Prosecuting Authority. So why his interest in a 1.2 million rand fraud?
Okay, but it still needs its time to be scrutinized in court.
It's going to be scrutinized in court, and the actions of the National Prosecuting Authority are going to be unpacked all over again.
Okay. So now let's get back to the Zuma case. What happens next now that the date has been set to, well, in a month's time from now, to appear in court?
I think it would be wise for the Supreme Court of Appeal, and it's not for me to tell the Supreme Court of Appeal what to do, but it would be good for our legal system for the Supreme Court of Appeal to hear the appeal, because it creates certainty in the sense that it goes to the second highest appeal court in the country. It's considered by 5 judges, and those judges will hear the merits of the matter. It won't be done on paper, and it won't be done in a manner where we can't see it. So it's going to be argued in open court, and the Supreme Court of Appeal will make a decision based upon what is presented to them. And I think that creates the certainty that we need as a society, and it also creates, or it fosters a sense of trusting our judicial institutions.
You know that the wheel of justice or the law turns very slowly, but this is anticipated that it could only happen, at least in a way forward, next year sometime.
I think what will happen is the time frame is that they've got to have the matter ready for argument in 3 months' time. And the Supreme Court of Appeal is very efficient in terms of its administration. So you can have an appeal argued in 6 to 8 months, and the fact in this case, the facts are that the paperwork has already been submitted. A preliminary decision has been made. So it's quite possible that this matter could be heard in the middle of next year.
Yeah. What do you think would be the compelling mitigation response from the legal team of the president in their argument not to reinstate the charges, as it were?
I think that they're going to take a number of approaches. As I said, they're arguing that it's not a decision, that the decision itself of the National Prosecuting Authority to withdraw is not a reviewable decision. They're arguing that the decision was rational. In other words, it was a considered decision. And I think that they probably will take the approach as well that this is harmful to the country to keep attempting to prosecute the president. The president has a job to do, and he is being distracted by all of these court proceedings. And that fundamentally is what their grounds of appeal already are.
Are you of the view that the president will see his or have his day in court?
I think that as an objective principle, so not linking it to any particular case, but a case that has such a high profile and such public interest, we need certainty. And the only way that that certainty can be created is a court process. Let a court make a decision. It's already been done. There's always a right of appeal. Let that appeal happen. Let 5 other judges make that decision.
Okay, so your short answer is yes.
Yes.
Well, a long way around about it,
Sorry.
Martin. But thanks indeed for your input. That's Martin Hood, a criminal lawyer. He's with MJ Hood and Associates, just reflecting on the latest developments regarding the spy tape saga.